if someone raises their hands, I don't think I can see it from my end, so they can let me know. All right. So, estate planning. A lot of times when people question or grapple with the thought of finalizing or sorting out the estate, they draw the conclusion that they need to make a will. However, estate planning can commence prior to one passing. And what I noticed in Jamaica also is that a lot of people, they do not like to make a will because they feel as if they make a will, they're going to die, like as a sign. But you know, that's a surety to all of us. So making a will is actually, I think, one of the good tenets of stewardship that the Bible speaks about. Also, estate planning can commence prior to one passing, in that you can start putting things together. And to be honest, putting your assets in place, both real and personal in place, while you're alive can work out cheaper and less timely. But one has to be sure that whomever they are entrusting with property and money, that they are responsible and are trustworthy. For instance, most homes in Jamaica are usually passed down, hence the term family homes. Sometimes these homes are passed down via will or word of mouth. And when it is word of mouth and there is no will, the estate has to be administered through the Administrator General's department. And I will explain the two estate processes during this presentation. So we're going to look at 3 ways of estate planning. That's the one prior to, which is called inter vivos, meaning while you're alive. Then there'll be estate planning via will. And there is estate administration. I wouldn't call it planning, because if there's no will, then there's no plan. So inter vivos estate planning. This would take the mode of someone, a property holder or someone with money, and instead of making a will, they would add a relative or a loved one to their property or their account while they're still alive. And this can be done in a number of ways. They can add the person to their home or any real estate, and they can hold the property together if they don't want to pass the property outright. So for instance, for Angela, let's say I have a piece of land and I want to give it to Angela. I can either one, add Angela's name to the title, so it would be Keisha-Ann Savage and Angela on the title, or I can pass it to Angela outright, meaning I would take my name off the title. Now, in Jamaica, there are 2 ways in which multiple people can be on property together. And one way is joint tenancy, and the other method is tenancy in common. Under a joint tenancy, everyone owns the property 100 full out. So if I should pass, whoever is on the title with me, the interest would automatically pass to them. And all they would have to do is note my debt on the title. Now, for joint tenancy, the principle is that everybody owns everything 100%. So no one can say, okay, well, the veranda is mine, this bedroom is mine, everything belongs to everyone. However, When it comes to transactional arrangements, let's say you are going to be selling the place, you will get your money according to how many of you are on the title. So if there are 2 of you, the proceeds of sale will be split 50-50. If there are 4 of you, 25% each. No, and under a joint tenancy, you cannot leave your property in a will. The joint tenancy will trump that section of a will. The other way in which multiple persons can hold property in Jamaica is by tenancy in common. And under tenancy in common, that's when your shareholding in the property is individualized. And it does not have to be in equal shares either. Using Angela again, using your name a lot today. So let's say Angela and I are buying a property, and Angela could only come up with the deposit, but I would be financing the rest. We could go on it, tenants in common, 1/3 to Angela, the other 2/3 to myself. And with that setting now, Angela can leave her 1/3 via will to anyone that she wishes. However, if she passes without leaving a will, then that 1/3 portion automatically goes to the government. And then somebody from Angela's family would, or her spouse, or it could be a friend that looked after her, or somebody close to her, can approach the Administrator General's Department to obtain that 1/3 share. So as I said, for the joint tenancy, when it's done while you're alive, so if one person passes, everything, the remaining interest goes automatically to whomever is alive. So the motto is like, who dies last wins, basically. Any questions on this aspect so far before I move on? Okay, no questions. All right.
Question here.
Yes.
Good evening, everyone. All right. In terms of the add name to property and the joint tenancy, well, I can understand that it's a bit cheaper and the joint tenancy passed down automatically to the party that is alive. What about the disadvantage or the challenges that comes with it while both parties are alive, and they know one party might want to sell and the other opposed to the selling of the property? What about that challenge that comes with it?
Okay. When it comes to a situation like that, you know, where one party wants to sell and the other party refuses to sell, that's when you're going to have to engage the services of attorneys. Initially, what will be required is some kind of mediation. Because as it is right now, because of the backlog of court matters, I think it started about 8 or 9 years ago. You can't just approach the court with a claim without first proving to the court that you made steps to try and settle. So court is actually a last resort. So basically what would happen is that you can use JPs as well, or attorneys. And I say JPs because initially this would be like a mediation matters. And JPs are the body that make up the Lay Magistrates Association, and they are equipped and entitled to do that kind of work. If it is that mediation is not successful, then you'd have to approach the court. And depending on the value of the property, it will determine the court that you go to. As it is now, If the value of the property is under $1 million or 1.5, that matter will be heard in the parish court. If it's over that amount, it goes to the High Court, the Supreme Court. And what will happen is that it would be up to the judge to make a decision as to what is the best way forward. And a lot of factors will be taken into consideration. For instance, if it is that two, or regardless of the amount of people that are on the property. All right, Santa Cruz, I see a hand up. So when I finish this part, you can chime in. And let's say a child lives there. The judge is going to weigh the balance of convenience. So if it is that the person not wanting to sell is the one with the minor, then the right of the child will always trump the right of the adult. So what could happen is that the judge could say, okay, the house can't be sold until the child attains majority age. Or two, if it be that the person with the child can find alternative accommodation, then it can be sold and a portion of the money is put on trust for the child. And it all depends on the circumstances, because if it's a married couple, that's usually how it would go. Because the rights and the interests of the child would be paramount in any situation. If it's just two plain adults, it would all depend on the merit of the case and which would be more feasible or more practical in the circumstances, whether to sell or not to sell. And if it be that, let's say Angela and I own a house and I want to sell and Angela doesn't want to sell, and the judge orders that it be sold, what will happen is that in the order, it will state that if Angela refuses to sign the court documents, then the registrar at the Supreme Court is empowered to sign the documents on behalf of Angela. So if she's being stubborn and doesn't want to participate, then, and of course, I'm telling you in 5 minutes the process, but this process can take years to settle. Yes, Santa Cruz, you can come with a question. I saw your hand up.
Yes, I was just helping with the questions.
Okay.
Just for a joint tenancy that there is a surviving owner, can it then be in a will at that point?
All right, so the person is saying if there are two people and one person dies, if it's only one person left, yes. However, if it's 3 people, one die, then none of the other 2 surviving joint tenants can will it. Or they can put in a will, but it will not be valid.
Okay, thank you.
Okay, what happens, I see a question, what happens in the joint tenancy if both parties die at the same time? It will all depend on the time of death. And the last person to die, that the property goes to that person. So it would depend on whatever the ME says as time of death. Say one person dies 101 and the other person dies 102. The one that dies at 102, the property is theirs. And if they didn't have a will because of the whole joint tenancy situation, then it goes to the Administrator General Department for processing. Now, to the process for adding someone as a joint tenant, it's done by a transfer by way of gift. And that's what the document is called, transfer by gift. So basically, you just fill out the form with the particulars, address of the property, volume and folio number, who is giving, who is receiving, and then you pay the relevant taxes. And the stamp duty is $5,000 across the board, and transfer tax is 1% of the value being passed. So let's say, for instance, my house is valued at 10 million, and I'm using simple numbers, so it's easy for me to calculate in my head. Let's say it's valued at $10 million and I am giving Angela 50%, then the taxes will be 1% of $5 million. And you pay that, you get the requisite certificates from the stamp office, you send the documents to the titles office, and the registration fee at that point is $5,000 as well. Any more questions? In the chat. Okay, all right. So now I think that settles the intervals passing of property. And the same goes about
One quick question.
Go ahead.
One quick question, Ms. Savage. I'm asking who determines the value of the property? Do you have to do a valuation of the property?
Okay. Sometimes you do, sometimes you don't have to. You have a 25% give or take bandwidth from the stamp office. What I normally do is estimate it, because instead of paying money for a valuation report, because a valuation report isn't cheap, what I do is I would go to the property tax website, and when you plug in the valuation number, it brings up certain information on the property. And one piece of information that would come up is the unimproved value of the land. Now, the unimproved value of the land is the lowest value that the land could be, and just the land alone. And to get the current market value, you times it between 6 to 9%. And you take into consideration the condition of the house, the area, things like that. And even if you do have a valuation report, the stamp commissioner still has a discretion to assess it higher, because revenue is revenue. And I've had experiences where I have battled with them, because I would send a sale agreement, and the property's been sold for like 8 million, and they would send it back and say, no, the place is valued at 15 million. And then we're getting a battle right there. And I usually win, like 90% of the time I usually win, but sometimes you just have to yield. But you can submit a valuation report, but it's not 100 that it will be accepted, because they still have the final say. So normally, the last time it happened to me, and I sent down the valuation report subsequent to them increasing the contract price, they still insisted on the higher price. Then I requested that they go and do a site visit, because yes, the house was in a upscale neighborhood, but it was very dilapidated. So when they went and looked at the house, they came back and said, okay, due to the poor condition of the house or whatever, we'll accept the original price stated in the contract. So there are little ways to Miranda around it. But if you can save the cost of doing a valuation report, I would suggest you do that. I see a question from Anna 9.
Okay, you made mention of the 25% give and take from the value. So that can still be applied to the unimproved value?
Yes. So let's say, for instance, because even say a house is valued at 10 million, you can sell it for 9. They won't reject it if you sell it up for 9 million. But if it's valued at 10 million, no, you're going to go with a $6 million contract without cause, meaning that the house set good, then it's going to raise the eyebrows. And they're going to say, no, these people, because this is Jamaica, and people try to beat the system. So to get out of some of the taxes, which is tax evasion and tax avoidance, what they do is let's say that the property is worth 15. They say, all right, do the contract for 12 million, and you give me the 3 million under the table. So the stamp commissioner is aware of all of these backdoor deals and things like that. So they're very strict with certain things. But if you're not far outside of that 25% bandwidth, it's not a problem. Okay, Anna 9.
If you're adding 2 persons, would the cost double?
No, the cost would not double. The cost would only double if you're adding them separate times. So if you're adding them at the same time on the one document, it's just the one, because you're only paying the tax on the 50% that's being passed.
Okay, thanks.
Welcome.
My question, so I just want to be clear, the unimproved value is the total for the land only, or
Yes.
for both the land and the house? So what if I have a big, massive house on it, and if the unimproved value is 9 million, that 9 million still stand?
No, man.
That big, massive house on it?
No, the 9 million is for the land alone. So that's the lowest value of what the land can go for, meaning that the land could be more. So if there's a house on it, it times it between 4 to 9%, depending on the type of house that you have.
Okay.
Yeah.
Thanks.
Yes, Anna 9.
Sorry about that. I'm ready to.
Okay. All right. So, and just a little FYI, before you can do anything in terms of selling or adding anybody to your property taxes have to be paid up. And you have to submit the certificate to the stamp office. They won't accept any documents related to land without the property tax certificate. So that's just as an aside information. Now, everybody clear on passing property while you're alive. And also you don't have to do it, as I said before, remember, you don't have to pass it and be joint tenants. It can be tenants in common. And tenants in common is usually like for I've seen it is mostly business ventures that do that kind of thing. The tenants in common. Okay. So if there are no further questions, and yes, SC. Okay, so if there are no further questions, and that we're gonna go to the will. All right. Now, in making a will, one, if you're completely clueless about what to do, seek advice. Information is kind of readily available on Google, so you can read and make sense of what there is to do, or if you still choose to engage the services of an attorney, that too still can work. Now, your will, it can be handwritten, it can be typed up, you can get the will form from the pharmacy and complete it. As long as it is readable and you sign it and date it and identify your beneficiaries clearly, your executors clearly, and your objects, meaning the gifts that you want to pass clearly, your will be valid. Now, when it comes to beneficiaries, and this is a thing in Jamaica, everybody or 90% of people have two names. Now, whenever you're gifting somebody in your will, you should only use the government name. If you want to put in the alias, you can put in the alias, but you need to also put in the government name, or else the gift will fail. So you can't say I leave to Chinaman $2 million. who is Chinaman. And it can be successful, but it's going to be a lot of paperwork to prove that this Chinaman is a Chinaman leaving the $2 million. So, your witnesses to the will cannot be a beneficiary. Conflict of interest right there. And but your executor or executors, they can be the beneficiary to the will. Now, let me see what the executors know. I would recommend that you have at least 2 executors, because anything can happen. One executor can pass away or refuse to do the work because it's a lot of work, and then it will just, if the executor passes, then it has to go to the Administrator General Department. But the gifts will be distributed in accordance with what is in the will. If you have executors or an executor who refuses to work, then the beneficiaries or a beneficiary in the will can approach the court for that executor to be removed, and they can take the place of the executor and probate the will. What else I need to tell you about making the will? In addition to, and when you make the will, let at least 2 people know that you have done the will and where the will can be located. If it be that you foresee that there may be some problems with dead left, I normally recommend to clients that they record the will at the RGD, Island Records Office. They prepare the will and they record it. The mere fact that you have taken an extra step, it does signifies that this is your genuine and true intention. Because a lot of family members come out of the woodwork when people die and say, oh, Dada, they tell me this, and then they will want to contest the will. And even though they may not have proper grounds to contest the will, the matter will have to be stalled until that is sufficiently sorted out through the courts. What else with the will? And also, you can update your will, because some people, after making a will, they will dispose of property or they can acquire property. The problem with disposing property now is that people won't know, and they will say, but I must get this house, but then the house was sold before the person died. So that would no longer fall in the will. Now there is if it be that the testator, that's the person who makes the will, passes after acquiring other property, other monies, etc., there is a catch-all clause at the end of the will that is called a residue clause. And in that clause, it basically says that all other property that you have and have not mentioned, but came into, will go to whomever, and you name whomever you want to get everything else in the will. Now, if the person is overseas and in the US, that will cannot be validated in Jamaica. Only countries part of the Commonwealth can have the will resealed in our courts and probated, and vice versa. Any questions?
Question here.
Mm-hmm.
All right. The format in which the will is written. Is there a particular format if it is unwritten or typed other than the form?
No, that all right. So the format basically, you start with stating your name, your address, your occupation. Then you state that you revoke all other wills previously made by you, and then you appoint your executors. Now you name your executors, give their address, their occupation, and then going down now, say I give. You direct them if you want them to pay your funeral expenses from your estate. You say that, and then you give the gifts after that.
What about an ordinary man who has no idea of the terminology that is being used, such as revoked and bequeathed?
Okay, so
Oh.
that is why in the beginning I said if you're clueless, you have no idea about going about the will, then it's best to seek the services of an attorney. So
What about
when
persons who don't have the money to seek the service of an attorney, but would want to write a will?
they can go to the legal aid clinic.
Okay, all right.
But you for bequeath and devise are legal terms. You can only devise property and you bequeath personality, money, jewelry, stocks, and things like that. Or you can just say, I leave the following for whomever. It doesn't have to be that technical. So if there's a layman, input everything and say, I give my house at 2 Blue Lane to Monica. That is sufficient. Don't have to use the term of art and be technical like that. Once the gifts are clear, once the person's getting the gifts name, they are clear, that is sufficient in disposing of the gifts. Any more questions on the probate? Oh, all right, the costing. Okay, so it is a bit pricey to do both probate and administration in terms of attorney's fees, etc. Now, there is a document that one of the commencement documents that is called the oath. So if there's a will, it'd be an oath of administrator. No, if there's a will, it will be an oath of executor. Sorry, and you stamp that document for $5,000. Most commencement documents that you need to start a matter with, they are stamped for $5,000. Now, the grant of probate, which is a sheet of paper that the judge will seal and sign, empowering whomever to act in the estate, that is stamped based on the value of the gross estate. So under $10 million, it's $5,000. 10 million to 14 to under 15 million is 10,000. 15 to under 20 million is 15,000, and it goes up like that in increments of $5,000. Outside of that, no, there are some antecedent documents that are needed to complete the estate, and these fees are varied attorney to attorney. So I'm just going to give you like the ballpark figure for some of them. Now, the document to commence any estate matter is called a revenue affidavit, and the attorney's fees to do that document starts from $90,000. I've not seen it being more than $150,000. You submit that document to the stamp office with the death certificate and a copy of the title, property tax certificate, of course, for them to assess the debt taxes. Now, debt taxes are 1.5% of the value of the estate. However, the taxman gives you one free penalty year. So let's say the person that's February 2018, you have until March 2019 to pay up. After that, you will attract 6% per annum on the amount payable until the date it is paid. However, there are some exemptions to that, where it is matrimonial home, or if it's a close family member like a son and mother relationship, or a mother-daughter, that kind of relationship, the taxes are usually waived because they take into consideration that the property is not at waste. So your taxes are being paid up, you're living there, and the land is not going to waste. So under those circumstances, there is a 100% waiver of debt taxes for estate matters. If you don't get it initially, you can send back and apply for it. But I just apply for it from the get-go because I don't take it that they're just gonna automatically give me the waiver without me asking for it. So that is done by a document called a statutory declaration. That you, in it, the applicant would say, I'm the daughter of so and so, and we've lived there from the date it was bought to the date of her death, and you're requesting that the stamp commissioner waives the taxes if he sees fit. If it is that the person died prior to 1974, no debt taxes will be payable, no matter when you're starting, because at that time the Transfer Tax Act on debt was not yet in place. So all debts prior to 1974, they are not applicable to transfer tax. Anna 9.
Okay, what if a clause is left in the will to say that a family member can live until that person dies, but you're not physically giving them any real asset, but they can live at the property in the will until that person dies. What if that family member take on a spouse?
Take on a what?
Spouse. Is it that automatically after 5 years that spouse can have any claims at all to the said property that the family member can only live in?
No, because that family member was not given an interest. What that family member was given is permission or a license. And it would be noted, and if it's in the will, it would also be noted on the title when the estate is completed that Angela Rose is given a life interest in the property until her death. And after her death, you will state what happens to it, if it's to be sold or if it's to go to somebody else. So taking on the spouse for 5 years would not affect it because she doesn't have a legal interest or an equitable interest, and if she doesn't have that interest, she can't pass that interest. She can't give what they don't have.
Another question, what if when the will is written, it's not probate for years, like over 10, 20 years, and another family member is paying the property tax? What disadvantage can that be to the probating of the will?
All right, it would all depend on the action of that family member. If it is that they want to claim an interest in the house, we'd have to go through the courts, because what they would have gained under law is preparatory estoppel. And that means basically whatever investments they have made to the land or the property, they're entitled to get it back. And then it would be for the court to decide how they get back that property. If it be money or they get by the house. Because what if the estate itself, by the time it's to be probated, cannot pay back that family member for all the investments. The court is going to have to look at everything and wait on the balance of convenience to see what is fair in the circumstances and decide from there.
Okay.
Anna 9?
Yes, thanks.
Okay. Right. So
A quick question. What is
go
the
ahead.
cost of removing a name from the title
All right.
in the case of the joint tenant?
Okay, so it would depend. It is the same 1% on the value. So adding it is 1% of the value, taking it off 1% of the value. And for the attorney's fees for estate matters, it's usually between 5 to 9% of the gross value of the estate. And the executors by law are entitled to 6% of the value of the estate. What provided that they have worked. It's not an automatic payment that they get by virtue of being executed. Any questions on that? Okay. Now we're going to move on to another aspect of estate, which is a. All right, N Black, you have a question? I see your hand up. N Black. Don't know if you're like, all right, on a 9, you're going again? See your hand up too. Yeah.
Yes. What if the will is written and it's registered at the RGB and you want to rewrite it? Can it still be done?
Yes, it can be done. And what you'll have to do is when you're sending the new will to be recorded, you just send a letter telling them that you're canceling the previous will. But even if you don't, just by virtue of you making a new will, it will revoke the previous will. And something else important I need to point out is that any subsequent marriage will void your will. So if you make your will last year and you get married this year, that will is no longer valid because your spouse is entitled to half the estate automatically.
Even if it's a prenup wedding?
Well, prenup is different, but without a prenup, your marriage will revoke your previous will. If you have a prenup, it's fine. If there's no prenup, it will revoke it. Any more questions on that? Okay. All right, going on now to administration of a will. Now you administer will when you administer an estate, sorry, where there is no will. Or if the executor or executors have died or refused to work or refused to do the estate. Now the documents are basically the same in terms of substance, just the titling is different.
Miss Savage.
Yes.
I have a question.
Okay.
All right, what happens if you acquire say you are separated from your spouse and you acquire the property during the period of separation? What happens? Is it still that 50% allocation, 50-50?
Well, it would and the spouse dies, like you die, the person that acquires the property dies, or you're both.
If the person is living.
Okay, what will happen is that if you're separated, then if it be that your spouse is claiming interest in that new property, they would not ordinarily get it, but it would not be so easy. You'd have to go to court to prove it.
Okay.
Because what would happen is that your action would show that this was never intended to be joint property.
Okay.
And this also happens if you're not separated, like you're actively married. Things like this can happen. Let's say, for instance, you're married and both of you have an account together or several accounts together and several properties together, and during the course of the marriage, one party gets property by themselves, gets another account by themselves or whatever. The court can read into it that this was never intended to be joint property, because if you have joint property already, why wasn't this part of the joint property? So it's just right. So it's just to look at the behavior of the parties that the court will determine what was actually meant by both parties. Mhm. Okay. All right. So back to the administration of the estate now. So when somebody dies without leaving a will, or the executor dies, the property automatically goes to the government. And now I think you have 15 years. Prior, it was 20 years before it would be taken over by, it would go to the government. They call it owner vacantia, meaning they would own it outright. So what happens is that you have to get a consent from the Administrator General for you to be the representative in a particular estate, and you have to pay for this consent, and it's $2,000. After you get that consent, then the same set of documents that you would have been prepared where there was a will, you prepare them for the administration, but they'll be called grant of administration and not a grant of probate. You'd have oath of administrator or administratrix if it's a female, instead of oath of executor. But it's the same process afterwards, getting the representative appointed. You have to advertise as well in the local newspaper that an application is being made in X and X's estate, just in case this person owed people or owed entities, they can claim against the estate to be paid off. And in the grand scheme of things, creditors rank in priority to beneficiaries. So, but the downfall of that is that naturally as a society we don't read, so a lot of people miss these advertisements in the newspaper, and then at the back end they lose. So that's basically it for the administration of the estate when there's no will or the executors refuse to act, or one or both of them die. So are there any questions?
Miss, in terms of it being published in the newspaper, I think it's very unfair on the other party's side.
When you say other parties, you mean like the creditors?
Not necessarily the creditors, because they would normally look at the gleaner or have specific person to do that. But like the other parties of the estate or the person that died, they don't read the gleaner. Some person cannot read.
Oh, you mean like beneficiaries?
Yes, if it is published.
Oh, no man.
That can be a disadvantage.
All right, where there's a will, right? Once the beneficiaries, all right. If there's no will, then it would be up to the administrator or administrators, to be honest, to advise the attorney handling the matter, or if it's not the attorney and they're doing it through the Administrator General Department, to advise them of all the beneficiaries. sad to say though, I know of cases where this does not happen, and then a valid and bona fide beneficiary comes forward at the back end when everything has been dispersed and finished off.
That's exactly what I'm trying to get
Yeah,
at.
yeah.
And that is unfair though.
It is.
Government should put measures in place to protect other beneficiaries.
It is, but let me tell you, it still happens because the Administrator General Department, they do investigate, they do check up and back up, and they do find people that even the family members don't even know exist. But sometimes one and two fall through the crack, and that's just what happens.
When you say they do fine, you mean persons who are under 18? That's what that's persons
who are under 18, other family members, because under intestacy, and intestacy is where there's no will, the act list gives a list of people who are entitled to benefit from the estate, right? So first you have the spouse, then you have the children, and it doesn't matter if it's children of full blood or half blood. So they do find them. And there's a particular active case now at the Administrator General Department where an applicant approached them, and the estate was finalized and completed, and she put herself as the widow of the deceased, and the estate was finalized, and she started getting payments because the monies in his estates were coming in piecemeal, and so as not to drag it out, they were paying as the monies came. They were paying out to beneficiaries, and it was on like the third payment, they got a hint or a tip from somebody that the man was divorced. So this lady is actually not his widow. Okay. And so what happened is that they stopped all payments to her, and this is happening right now, as I said, and she called them, sent threatening emails and stuff. It's now with the fraud squad. Reports had to be made because of her threatening and what she's gonna do and what she's gonna burn down and everything like that. So it does happen.
Another question. So if the person now becomes the administrator of the property, and then that person has to have trustees in order to do the necessaries, like pay the debtors and...
No, that administrator is quasi-trustee, because that's what they're called, administrator/trustee. Same thing for the will, you're called executor and trustee.
So they don't need any other additional trustees along with them?
No, they don't. Not unless the testator states that they're going to be using the trustee in bankruptcy for a particular section. And that's for more complex estates.
Okay. Okay. Thanks.
Okay. A quick question here, Mr. Savage. I can see where you can get around making a will by like transferring property. In insurance, you can name beneficiaries. You can have joint accounts. The part that I wouldn't understand is like your personal effects. How could you deal with your personal effects outside of a will?
Give it if you want to give it to them. No, we give it to them. If not, you can leave a letter. But once you die, it is considered death property. So it's best you give it. No, like if you know you're undying or something, you can give it. No, like your jewelry and stuff like that. But some people do list them in the will. So.
Okay. Thanks.
You're welcome. Any more questions? Okay, so if there are no more questions, just a little like FYI, when it comes to gifting stuff like motor vehicles as well, you would also need to be particular. And I notice now that the tax office, they are becoming strict. So they want not only the make of the vehicle or the color, they want the chassis number and engine number as well of the vehicle that you're gifting, that you're describing in the will. But as I said, the residue clause that would cover any other property you come into after making the will, it would automatically fall to that. But once you are describing a vehicle, that needs to be, it wasn't like that before, but I guess with all the scamming that's going on, it's not a requirement.
But I'm also thinking that when you're alive, you can put the person's name on the title of
Yes,
the car.
Yes, you can, but some people don't do that. So, yeah.
Okay.
Yeah. Yes, Honor 9. Honor 9, your hand is up.
Okay, yes. What about cases where a single parent have kids, no will is written, and they are underage, and that person die?
Straight Administrator General Department. Once they're
Still have
minors,
to administrate on it?
yes, still is straight, and that is strictly for the Administrator General Department.
Okay.
Even if an adult member of the family comes up, they will work in conjunction with the Administrator General Department, and the Administrator General will not dispose of all the funds until the children or the child has reached the age of majority. So what they will do, they will release monies periodically for school, or if there's medical expenses, you have to show what is needed for, and they will pay out on it. They don't pay out everything one time.
Okay.
On a 9, okay.
Point well taken.
Okay. If I was prepared after marriage and I do not leave any gift to my spouse, will the law? Okay. If it depends, because the will, if you prepare the will after marriage, that is your intention, and the court is gonna give credit to the testator's intention, unless it is so unconscionable for the spouse not to get anything. Like, for instance, let's say you took ill, and your spouse basically quit her job or his job to look after you, and all those sacrifices and stuff like that. Even though, and there are cases like that, even though the standard is what in the will stands, if it's unconscionable in all the circumstances, the court will give the spouse something, not 50%, but something. And I've seen wills where a mother has 3 children and she'd leave 2 houses to Catherine and $30 million, and another house to Christine and $25 million, and then to Beverly she only leave $1,000. And the court
Will the court honor that?
Yes, it was honored. And it's obvious why that daughter received only $1,000.
As Beverly treats her bad while she was alive.
Correct. So that is why, as I said, when it comes to the spouse, or whoever, even if Beverly didn't treat her bad, because you'd have evil parents like that. So if it was in the reverse, where Beverly could prove her acts, then the court would decide on a percentage that would be fair, because it's all about fairness and equity, and where the equity and the law clashes, equity will always win, because it's what is fair that will stand.
So what if Beverly was totally left out of the will and she wants to contest the will? Can that be done?
Yes, you can. Yeah, you can do anything you want. You can contest, but that doesn't mean you're gonna be successful. So, and worse, if the testator recorded the will, that would have further showed her true intention to leave out Beverly. Beverly would have to show, the onus would be onto Beverly to show why. There's a question there, I didn't get to see the rest of it. I soon go back to it. Beverly would have to show why, because the law says he who asserts must prove. So if you're asserting that you are to get something, you need to prove why you should get something. And if you can prove, then your claim will fail. A question. Can I just write a will and have a friend witness it and put it away at home? Is that will viewed as valid, or does it have to be witnessed and given to a lawyer? Okay, first you need 2 witnesses, not 1. And since you're just joining, a witness to a will cannot be a beneficiary. And it doesn't have to be given to an attorney. You can put it up, but at least let somebody that you trust know where the will is. And put it up somewhere safe.
All right, thank you.
You're welcome. And when, before I forget, in doing the probate, if 3 years pass and you have not commenced the, how to get this out. You have not commenced the probate, there's an additional document that you will have to do, and it's also for administration. It's called an affidavit of delay. Because you have 3 years, allows, the law says you should commence within 3 years of passing that probate process. But you need to pay up the taxes within a year of the date of death of the person, or else you'll pay a penalty. And then basically the affidavit of delay, you're basically saying that you weren't trying to delay paying of any taxes or trying to withhold monies, but you genuinely didn't know that there was a timeline to commence this this matter. And in truth and in fairness, a lot of people don't know these things. So
where can one get a transfer of gift form? Where are those forms available?
All right, those forms are available on the land agency website, and the website is www.nla.gov.jm. However, the forms are not strict, because not all matters or transactions are the same, and I have had instances where I have had to create a transfer document. But what I do is, after I draft it, I run it by the registrar at NLA and say, hey, this is the situation, so I can't use your form as a tested format. So I have to do it this way. And she look at it and say, this is fine, or put this in, or take this out, and we'll take it from there. But you just title it the same thing.
Okay, thanks.
You're welcome. Anna 9.
So Miss, you're saying that the will doesn't necessarily have to be witnessed by a justice of the peace?
You just need 2 ordinary witnesses.
Okay, all right.
So you have the witness name, the occupation, and the address. And the reason for this is sometimes, depending on the handwriting of the testator, the court may find it odd because at a state the handwriting may seem shaky or just not like a regular signature. I don't know if there's a standard for a regular signature. So what will happen is that one or both of those witnesses will have to do an affidavit of signature saying, hey, I was there when Mary Blue signed and that was her signature.
And they don't have to go to court though?
No, no.
Okay.
Not unless it's being contested by somebody who's saying Mary Blue didn't sign it.
Okay.
Mhm. Or if something happens to the will, like you get wet up or coffee drop on it, and you know, the witnesses will have to say, well, this is the will and this is the signature, but this happened, you know, or I'm informed that coffee spilled on it and I believe that the coffee spilled on it.
And the witnesses should know exactly what is in the will before they sign to it?
Not necessarily, they don't have to, but what is important is that they see the person sign the will and the person say, this is my will, I'm gonna sign it.
Oh, okay.
Yeah. I think I have another question.
Not with a formidable spirit.
Somebody's asking why is the process so lengthy? And this is just my opinion as to why the process is so lengthy, is that we still use the British format from prior to independence of doing certain documentation, and it's not just the will. Even I find it the process the same way in doing divorces. Like certain paperwork I don't think is necessary, and we are petitioning for changes at the moment. We meaning the Bar Association, for certain changes, because the paperwork, certain paperwork is not necessary. So I can do in a divorce. I filed a petition and I want to divorce my husband, and it is signed and I serve him. I have to file other documents saying, basically, yeah, I still want a divorce. And it's kind of the same with the probate thing. Everything takes a little while, and because of scamming, everything takes longer because everything and everybody have to be vetted. Every land matter has to be vetted 2 or 3 times to ensure that whoever is saying at the past in the title or was on the title is legitimate. Sometimes you'll have a father named Ted Brown, son named Ted Brown, the father dead, but then the son sell the property as if it's his. So everything is just has to be streamlined and double checked and triple checked before it goes through. That is one of the things. And I think the court staff could use a bolstering of staff complement, but that's not for me to decide. So
The memories made with it.
Come again?
Miss Savage,
Yes.
Let it assure
scenario.
Mhm.
I was married
Mhm.
for over 20 years. I left my husband, migrated to United States of America. He was left in Jamaica.
Mhm.
He gained a lot of success financially. Wasn't a part of his life. Eventually, he died. What are my shares? What do I get?
Well, if he left a will, it will be according to the will. But if he didn't leave a will, then the matrimonial home, which is the house that you would have left, would be 100% yours. And then everything else, if there are children, it would go according to how the Intestacy Act rules. So 50% you, and then everything shared up amongst everybody else afterwards. If
Please
it's just
repeat.
all right, if he left a will, it would go according to his
Hello?
will. You're hearing me?
Miss Savage?
Yes, you're hearing me?
Yes, repeat, please repeat.
I'm repeating, but I'm hearing like somebody's TV.
No, it's not a TV.
Okay. All right, I'm saying it would depend. If he leaves a will, everything would be distributed according to what is in the will. If he did not leave a will, then the house, remember the house that you lived with him in before you
Right.
left, that would
Right.
be all
Right.
yours. That would be all yours. And everything else, if there are children, the breakdown will go according to what is in the Intestacy Act. Meaning the wife, the spouse get 50%, and then everything else is broken down amongst the children.
Okay.
If there are children. They are not children, then
Okay.
basically everything is yours. And
Okay, thank you.
And if I just want to put in this because it's a general question that I get, that and it happens a lot, you know, people are married and then they're separated. Like in your case, you said you'd have gone away for the 20 odd years, and the man bringing a woman living with her. She wouldn't be entitled to anything as spouse, as common law spouse, because you cannot be common law with somebody who is married. It has to be two single people living together for a period of 5 years or more. So that is an aside information. So even so if it is that you're separated for the 20 years and you die the day after the 20 years, the 5 years for the common law spouse thing doesn't start to run until after that time. Any more questions? Okay. Well, if there are no more questions, that's basically, okay, what if, hold on. Let me bring up this. What if father and son have the same name? Would there still be a need to transfer a name and title to the son? Or is it dealt with by law? All right, now, so that is the tricky part of it. As I said before, it has happened where father and son have the same name, and the son sells the property from under the father's foot, or the father dies. And so I don't think at the moment, even though TRN is in place, TRN requirement only came about, I think, in 2008, 2009. Prior to that, transferring people onto property did not have TRN on it. So that is how some of the scamming takes place in Jamaica right now. So that is a very muddy area. If it was done, if the father's name went on the land prior to 2009, his TRN would not be on it. So the son, if he has the same name, the father just has to hope and pray that his son is honest.
I am thinking in this case, if the father has died.
All right, so if the father has died, the son can proceed, provided that the TRN is not on the transfer document that would have put his father's name on it. So if, say, the father died, the father got the property in 2015, TRN would be required. So if the son is going to treat with the property, his TRN will be required, because for every land document that is being started at the stamp office, you have to include a TRN. But if it's prior to 2009, 2008, that would be a great area right there. And even with the TRN, things do slip through the cracks, no matter how tight, and I'm talking from experience, no matter how tight security is, things do happen. I have transferred property before, and the transfer was not noted at the titles office, but noted because what happens is that there are two titles. The original is kept at the titles office. What you have is a duplicate, but it looks like the original, but you can't have two original for thermal card. And what happened is that when I did the transfer, by some error, it was not noted on the original title, but only noted on the copy title, which is what was given to the new owners. So when I tried to amend the tax roll, the land valuation told me, sent it back and rejected it. I said, I can't amend the tax roll because no transfer had been done because they are using the records, the original records from the tax office. So I had to provide them with my copy title, a photocopy of it, to show them that the transfer was done. And I mean, you know, if I was a rogue person or my client was a rogue person, he could have just applied for a lost title, gotten a new title, and sold the property again. So everything is not 100% safe and not 100% tight. So I always encourage my clients, like once a year, just go to the titles office and check on the title, check on the status of your title. You don't know if somebody put a mortgage on your title and you don't know, and you're at home and they come and move you out. You don't know if somebody has sold your house. I have somebody close in my family, her house was sold and she didn't sell it, and NHE was part of the sale process, and NHE is usually a good watchdog.
But Miss, can that be done when normally they are doing documentation? You'll have to get the valuation and the tax number and the tax rolls. How can that be done?
I can't tell you, but it has happened. If it never happened to me, I wouldn't believe it.
Seriously?
Yeah.
Oh, God.
Yep. I have somebody close to me and her house was sold and she never sell it. And there were two titles out for the same property. And NHD paid out money, and NHD is usually a good watchdog. So I'm saying no matter how good or how tight you think your security is, always check up on your title at least once a year.
So in that case, what do you do when you're checking on the title at titles office? Which form?
No, you just go to customer service or information and tell them you'd like to do you can do a caveat search. A caveat search would be the best one to do, because that would show if anybody, one, has lost a caveat against their property for whatever reason, or two, if anybody has taken out any loans using your house as collateral and you don't know.
And that can be done online, or you have to go in person?
For the caveat, you have to go in person, and it takes 48 hours.
Oh, but you'll have to have the land val information, right?
Or you give them the address because it's NLA, so they have all the addresses.
But sometimes when you use the address, it's very challenging. They want the land val number, the volume and folio.
Well, if you have it, give it to them, but normally the address can work.
Oh. Okay.
Yeah. That's basically I always encourage people to do that.
Excuse me. That can be done at the NLA office, or you have to go to the Kingston one, or it can be done at the different branches?
I think it should be able to be done at the different branches. I don't have any experience with any other NLA office outside of Hanover Street. But I think if you're in Mobay, you should be able to get it, albeit the information would come from Kingston. So I think they would just put in the request from whatever location they are. And
all right. So Miss, that's where you were?
No. I have my own office downtown. Close to NLA. Close to everywhere that I need to be close to keep an eye.
Okay.
Any other questions? Let me see if I got all the questions in the section. Okay. Okay. I think I've answered all of them. Wait, I have one new message. Okay. Yes, and as a reminder, if you're getting married, if you have already made a will, and it's some more technical relationships, a prenuptial agreements would be, especially if you have like children from previous marriages or marriage that you want to set up, then in order to make life less complicated, you do that, or else whatever marriage you have subsequent to making the will, it will revoke the will completely. So are there any more questions? Oh, I'm not seeing anything else. Okay, so I guess that's it. Yes, you can. I will give my number out. I don't know how to. I don't think I have it on my system here, but I will pass my card. I will give my e-card to Corona. Hello?
The loss of your darling and supportive husband must be a huge problem.
Yes, give it to Corona and I'll get it and I will share.
Right, I'll give her my e-card and so it can pass. She can pass it out. All right. So that's it. I want to thank you all for having me and for listening and for asking questions. I know that you were listening. Hope I didn't bore you any at all. And I answered your questions sufficiently. I see Katie.
Thank you, Miss Savage.
I see a question. Katie has raised her hand. Oh. Okay.
Yes, I was wondering. So my mother was on my title and I never want to, I just put her on my title because in case something happened for my apartment, but I want to sell my apartment. Sorry, I never asked the question earlier, but if I want to sell my apartment, I have to tell her, I have to give her some of my money because she never give me no money for it.
Okay. In principle, once anybody is on a property, once the property is being sold or has been sold, everyone on the title is entitled to a portion of the proceeds pursuant to their contribution or their interest on the title. So if it be that you had put your mother on it and the intention was just for her to be on it, then some kind of communication or agreement should have been made prior. Because if it be that at the back end, if the property is sold and the mother should come and say, hey, where's my portion? And she takes it to court, you'd have to give her half. You could appeal it to show basically she didn't pay anything upfront. But in principle, once somebody's on the title, they're entitled to their interest on it, regardless if they put up any money or not.
Okay, that's not fair, but Thank you. Thank
So I
you.
hope you give her some money.
Yes. Okay.
Okay.
All right. Thank you.
Any more questions? Mhm. Okay. And thanks for you all that are sending me messages about the presentation. I'm so happy I was able to share. And trust me, in sharing this information, it makes my work easier. So this is kind of my give back to get back. So I do go around the island from time to time. This is my second out of parish for the year. St. Thomas was my first vocation, SD Church, Albion SD. And now St. Elizabeth's New Testament. Yes. So I hope to continue this work because it will make everybody's lives easier in the end.
Thank you, Ms. Savage, for a well-researched presentation. I can assure you that my fellow members have learned immensely this evening and are a little wiser in carrying out their estate planning. Rest assured, if and when we need you, we will always call on you.
Okay, then. I look forward to hearing from you all. And thank you for having me.
Yes, ma'am. You're most welcome, Ms. Savage. God bless.
Thank you, and God bless you too. Bye.
Thank you too.
Stand and help me welcome Travis Green, everybody.